Yes, it can be sad news to learn that a parent or relative needs to go into care, and it can also be sad to find out that you could lose that inheritance in order to pay for their care. Sadly, it's happening all too often nowadays. It can be even more upsetting to understand that this was wholly preventable, because we're going to show you how to protect that inheritance. It's legal, it's simple, and it is robust. What it does need, however, is some advanced planning. So let's agree what exactly is at-risk here. Everything you have will include your house, savings, pension income, even your business. In fact, it's a legal obligation of social services to recoup funds wherever they can. The list law states that everything over $23,250 will go towards the full cost of someone's care. So it might make sense to reduce the value of those assets below those limits in order to keep what you have. We're often asked, can we not just give our money away, give our house away? Many instances where parents transfer the deeds of their house into their children's names is not recommended for many reasons. We often hear things like it's outside time limit after 7 years, after 2 years, or any such times. The answer is, I'm afraid not. And this is due to a small phrase called deliberate deprivation. It's a phrase which is used often in the courts by social services, which effectively means that where someone were to dispose of an asset with the intention of reducing their financial burden to social services, the law states that they have more powers than even a trustee in bankruptcy. They can take back ownership of a property to pay for your care. And the time limit set for same, there aren't any. So when a couple own their own home jointly and one dies, the remaining sole owner is very much at risk. And the house can be sold to pay for care. Similarly, without the proper planning, if both parties should go into care during their own lifetime, who inherits the house in that instance? Is it your children, your grandchildren? Nope, there's a steamroller heading your way. No ifs, no buts. That house will be taken and sold if needs be. And yet we do have a solution that works whether you're a couple, married, divorced, single, separated, widowed, whatever. It works if you have a mortgage or you have a no mortgage. We put a protective wrapper around that which is yours so you can enjoy it in this life and still pass it on as you had always intended. Now that's the house sorted. Next, we're always asked, what about my cash? What about my investments? The answer, of course, is a very simple yes, just a different trust. Let's debunk a few more myths here, because this is a situation where you're not giving anything away. This is your money. You control it. You can spend it. You can enjoy it and leave it to the family of your choice. So please don't leave it until it's too late. With our specialist wills and trust planning, we do appreciate it's a delicate subject. However, it's probably going to be the largest inheritance that you are expecting to receive. Do get in touch.